Have you ever had one of those moments with a neighbor, where their idea of a perfect backyard paradise is, well, your personal nightmare? Today we're going to dive deep into one of those exact situations. It involves a giant outdoor TV, a super frustrated homeowner, and a seemingly airtight HOA rule that got put to the test and led to a legal battle with an outcome you might not see coming.
All right, let's start with the rule at the very heart of this story. This is Section 5.4 from the community's rulebook. I mean, it seems incredibly clear, right? It says nothing shall be kept on a property that will or might disturb the peace. That little word might, wow, that seems to cover just about anything and everything.
So, with a rule that strong, you'd think any problem would be a slam dunk to solve. But let's see how it actually played out. Our story kicks off in a quiet neighborhood in Tucson, Arizona, with a homeowner named Anthony Payson. He moved into this community expecting the very peace and quiet that rule promised him. That was about to change.
The trouble started, as it so often does, with a construction project. Mr. Payson's next-door neighbor put up this big, freestanding block wall in their backyard. We're talking about 8 feet tall and 8 feet wide. But it wasn't just a wall. Oh, no.
It was built for one very specific purpose: to hold a massive 70-inch outdoor television. His neighbor had basically built themselves a personal outdoor movie theater. And the way they designed this thing, well, that was about to become a huge problem.
See, the screen wasn't pointed back at the neighbor's own house for their family to enjoy. No, it was aimed directly at Mr. Payson's property, sitting only about 50 feet away from his property line. You can already see where this is going, right? The potential for a noise issue was, let's say, pretty obvious. And that potential? Well, it very quickly became a reality. Mr. Payson testified that one night, a hockey game was on for 3 straight hours, and the noise completely invaded his home. He specifically remembered the shrill sound of the referee's whistle echoing throughout his house.
So after trying to sort it out with his neighbor and then going to the HOA management company, Mr. Payson felt like his back was against the wall. He had no other choice but to take formal legal action. He filed a petition, and the case was sent to the Office of Administrative Hearings.
Now, this entire case hinges on the community's governing documents, which are called the CC&Rs. If you're not familiar, these are basically the legal rulebook for the whole neighborhood. When you buy a house in an HOA, you're legally agreeing to follow these rules, and the HOA's job is to enforce them.
And this is a crucial point. Mr. Payson didn't sue his neighbor for making all the noise. He actually sued the Homeowners Association itself. He argued they were the ones failing to do their job.
He made his argument crystal clear right in his opening statement. He said, look, this isn't about my neighbors. This is about the HOA failing to perform its duty, failing to enforce the very rule we saw earlier, the one that's supposed to prevent this exact kind of thing.
And that set the stage for a really fascinating legal showdown. It was Mr. Payson, representing himself, going up against the HOA's high-powered attorney in a virtual hearing. And their strategies, well, they could not have been more different.
Okay, this slide really breaks down the whole conflict. On one side, you have Mr. Payson saying, hey, the rule is obvious, the TV is a nuisance, and the HOA has a duty to do something. But the HOA's argument was completely different. They said, first of all, that rule doesn't even apply to us. Second, you have no hard proof of a nuisance. And third, and this is the big one, we have the right to enforce, not a legally binding duty.
The HOA's lawyer really hammered on that lack of proof idea. During his cross-examination, he kept asking Mr. Payson if he had ever provided the HOA with any concrete evidence. Things like official police reports, or a professional noise study, a detailed logbook of every single time he was disturbed, or even video evidence. So, the big question is, did he have any of it? Had Mr. Payson actually documented all of this with the kind of hard evidence the association was asking for before they would step in?
The answer was simple. And from a legal strategy perspective, it was devastating. No, he had not. His entire case was built on his own testimony and his reading of that rule.
So after hearing all the arguments, the judge issued her final written decision. And the whole thing didn't come down to whether the TV was annoying or loud or a nuisance at all. It came down to a critical and kind of tricky legal distinction.
And that distinction was something called jurisdiction. Basically, it means a court can only make decisions on issues that it has the legal power to actually address. In this case, the judge could only rule on one thing. Did the party being sued, the HOA, violate the specific rule that Mr. Payson accused them of violating?
So here it is laid out in the judge's own legal conclusions. That rule, Section 5.4, the one about noise, it's all about what homeowners, the members, can and cannot do on their lots. But the HOA, it's an association, it's an entity, it's not a member, and it doesn't own a lot. So the judge concluded the HOA itself could not possibly be in violation of a rule written for homeowners.
And based on that simple, logical conclusion, the judge's final order was just one word: dismissed. Mr. Payson's entire case was thrown out. So what in the world just happened? How could a rule that seemed so perfectly designed for this exact problem end up being totally useless for the homeowner? Let's break down the big takeaway here. It really all boils down to this. Mr. Payson sued the wrong entity for the specific violation he was claiming. He said the HOA violated Section 5.4, but the judge found that legally, only a homeowner could actually violate that rule. He might have had a case against his neighbor, sure, but not against the HOA under that part of the rulebook.
And this just brilliantly shows the legal traps so many homeowners can fall into. Mr. Payson, like most of us would, believed the HOA had a duty to enforce the rules. But the HOA's lawyer pointed to a whole different section of the CC&Rs, one that said the association had the right to enforce the rules, but not an explicit, legally mandated duty to do it every single time. That one-word difference, right versus duty, turned out to be everything.
So, it's pretty fascinating when you think about it. The judge never actually made a decision on whether the giant outdoor TV was a legal nuisance or not. The whole case got thrown out on a jurisdictional technicality before they could even get to that question. The actual complaint became completely irrelevant. And this whole story leaves us with a really powerful and honestly kind of unsettling question for millions of people who live in HOAs. We join these communities expecting the rules will be enforced to protect our peace and quiet. But if the legal documents only give the board a right to enforce instead of a duty, what real power do homeowners have when a neighbor decides to cross the line?